and the Zoom.
Mr. Chairman, we are live.
Oh, thank you. All right. Well, this brings us to another day of the Judiciary Committee. We're meeting a little earlier than normal, and that's because, I'll just say, one time a while back, I said I thought I want to be on Judiciary, and I thought maybe I'd even want to chair it. And I remember one of my older colleagues saying, "Why in the world would you want that?" And it's the bills that we consider. I mean, we may process through one bill, but that's because we take on the truly deep, substantive, and controversial issues, and bring people from all over Wyoming to testify from all different walks of life and all different political spectrums. And we haven't even gotten to the really spicy ones yet. So just love the Judiciary Committee. Kay, would you please call the roll?
Yes, sir. Representative Crago,
Here.
Representative Larson.
Excused.
Okay. Representative Oakley,
Excused.
Representative Oakley.
Excused.
I'm sorry.
Yeah, sorry.
Representative Provenza,
Here.
Representative Williams,
Here.
Vice Chairman Washut,
Here.
Representative Yen,
Here.
Representative Swanitzer,
Excused.
Chairman Olson.
Here.
Chairman Olson, you have 6 in attendance and 3 excused.
All right, thank you. And I suspect, Kay, that those legislators will filter in this morning. They have other legislative obligations, and so as they filter in, we'll just call them in back in
Okay.
to the process. All right, so we'll continue hearing House Bill 213, disclosure of peace officer recordings. We left off with testimony from our legislative colleagues, and I had kind of mapped out a path in terms of testimony on where we would go. I was thinking I would move to Colonel Haller next in the YouTube. However, Colonel, I'm going to ask you to just pause for a moment, because between now and then, and this is one of the great things about the Zoom world, is many people paid attention to our hearing yesterday, and now many more people want to testify, and I'm interested in hearing from them. Particularly before we had left, we heard testimony from one of our legislative colleagues about Platte County. And as it would be, we have an individual from Platte County who would like to testify. So I'd like to, Clarissa, bring in Salvador Jaimez, who should be in our waiting room. And I probably butchered that last name, so I apologize, Salvador.
Mr. Chairman, Salvador has been admitted to the meeting.
Thanks. Salvador, you can go ahead, and we can't see you until you light up your video feed. And then let us know you're here. Maybe. All right. We can circle back to Salvador. How about Deborah Hinkle? We have Deborah Hinkle in the waiting room.
Mr. Chairman, I do not see Deborah at this moment, but
Okay.
S. Kilwine and Mr. Barron have raised their hands.
Okay. Yeah, let's go to Dr. Kilwine. And Clarissa, can you send Mr. Salvador a chat message then?
Absolutely.
Thank you. Dr. Kilwine, please introduce yourself, full name for the record, and then tell us what you want us to hear.
Thank you, Mr. Chairman. Good morning, everyone. My name is Dr. Tess Kilwine, and I'm a licensed clinical psychologist and trauma specialist practicing out of Laramie, Wyoming. I wish to speak against the notion that we should not release body camera footage in the case of police-involved shootings because of its potential to result in PTSD. While not impossible, body camera footage is exceptionally unlikely to give someone PTSD. In the context of a jury trial, we never give jurors discretion over whether they do or don't wish to see certain parts of testimony in the case of violent crime. There is no widespread evidence to suggest that jurors develop PTSD, despite there being hundreds of violent crime trials with gory photos and crime scene evidence annually. Second, witnessing violence without personal endangerment or threat to life oneself, especially when further removed via media exposure as opposed to witnessing in person, results in a very low likelihood of developing PTSD. Third, should the video be somehow publicly accessible, they're A, usually accompanied by content warnings, and B, people have discretion to view or avoid the footage as they see fit. Now, I have also done extensive work with individuals who have developed PTSD based on repeated exposure to traumatic events, like post-combat war veterans and firefighters, family members who have developed PTSD based on exposure to the traumatic details of what has happened to a loved one, and collective trauma that results from community violence. This is the reality, and preventing the release of body camera footage following police-involved shootings does nothing to change the experience of trauma that is already felt deep within the bones of those impacted. What I know from this work is that while the initial trauma certainly has an impact, it is often what follows that traumatic experience that determines one's recovery and healing. When individuals and communities are not given a choice in how they best want to grieve and process an experience, when they are not given an opportunity for transparency or to ask questions, and when they are faced with constant litigation and dismissal, that is what prevents healing. That is what promotes and maintains PTSD. Now, it is almost certain that those who will be impacted by the public release of body camera footage in the case of police-involved shootings are the family members of the victim. I point out that we have existing models for how this can be done right. Families should have the chance to opt out, be given the chance to view footage prior to release, and always be given advance notice when footage is to be released to the public. Release of footage should also be as prompt as feasibly possible. If those opposed to this piece of legislation truly have the best interest of victims' families in mind, they will be willing to have a nuanced conversation about balancing the already existing trauma with the benefits of releasing footage. Families aside, I might argue that the government should not be serving the function of deciding for its citizens how they might be impacted by accurate footage of real community events. The individual freedom and liberty perspective that this state values would be consistent with allowing the citizens of Wyoming to decide for themselves whether they wish to view potentially distressing footage. And in conclusion, I will remind folks that the discomfort that one may experience from observing body camera footage pales in comparison to the very real threat and fear that is experienced when the people expected to prioritize safety and well-being of a community commit acts of violence with impunity. Thank you.
Thank you, doctor. Do we have questions for the doctor? All right. Thank you, doctor, for your testimony.
Thank you.
All right, Clarissa, who do we have in the waiting room with hands raised?
Mr. Chairman, it appears that Salvador has joined us.
Okay.
He has his video on.
Let's try that again. All right, Salvador, all you have to do is unmute and introduce yourself for the committee and then tell us what you want us to know.
Hi, Chairman. So my name is Salvador Jimenez. I'm the nephew of David Matthew Kane, the one who was shot by the sheriff in Platte County. I can tell you that the transparency as far as the video recording went was pretty difficult. Between DCI and the Platte County Sheriff Department, they played a game of just going back and forth between calling them for several weeks on it. They would never give us real clear directions on how to access the video footage. They just made it an overall very difficult process and just had a way of making it sound like we weren't allowed to see the video at all. And they just say that we need to contact the other in order to get access to the said footage. And it just went like that for a few weeks. And then we just didn't know how to go about accessing the video footage to see what happened with my uncle and just getting the truth. Thank you.
Thank you, Salvador. Questions for Salvador? Representative Provenza.
Thank you, Mr. Chairman, and thank you, Mr. Salvador, for being here today. Have you been able to access the footage of your uncle's officer-involved shooting to this day?
No.
Follow-up, Representative Provenza.
Have you been told why?
No, they would not give us any particular reasons at all. And several people have tried, include my mother, his mother, which would be my grandmother, and and the mother of his child. So, and we've all tried, and they still they did not make it easy in any way.
Well, Salvador, we appreciate you sharing your story with us, and obviously it's a very personal story. I don't mean to get too personal with it, but I am curious if you don't mind sharing. It sounds like your family wanted to see the video. Why did your family want to see the video?
The main reasoning is obviously the shooting was justified. And for me personally, it's that I just want to know the truth. That's just my main reasoning for wanting to see it. I want to see if it was actually justified in any way. I want to see that he actually raised the acts according to the said report. I want to see all of it. I just want to make sure that was the truth, and that's the main reasoning. And then, because according to my immediate family members, my uncle, who was there when it happened, right there when it happened, claims that didn't happen, and I would like to know for myself. And my grandmother and mom, who were in the other room, which still connects to the same kitchen where it happened, I guess they would also like to see the footage as well to see that that's what truly happened.
Thank you. Committee, any further questions for Salvador? All right, we do appreciate you. Thanks for joining us.
No problem. Thank you.
All right, Clarissa, who else do we have with raised hands now?
Mr. Chairman, Deborah has joined us, and Mr. Barron has also raised his hand.
And yep, okay. I got Mr. Barron. I'm just trying to move through some of the public first, Mr. Barron. So don't worry. I'll definitely get to you. Let's go to Ms. Hinkle.
Mr. Chairman, she has been admitted to the meeting. She just needs to turn on her video and mic.
Thank you. Yep. So we can't see you yet, Ms. Hinkle. I don't know if that's intentional or not.
Okay.
Hi, please introduce yourself to the committee and share your testimony.
Okay, just a minute. I'm ending up with two things going here.
Oh, yep. Yep, that happens a lot. You
There we
probably have the YouTube in the back.
All right. Yes, I am Deborah Hinkle. I'm from Laramie, Wyoming. I have been very actively involved with advocating for people with mental illness, and that's been my biggest role in Laramie. I've been the president of NAMI Laramie for 14 years and have run a support group for those people dealing with mental illness that have loved ones that are suffering with this and that need some help and someone to vent with. I've also been the chairman of the Albany County Mental Health Board for 3 years until this past July. I introduced CIT to Laramie. And so I sat through 6 40-hour trainings. So I'm very familiar with the police officers. I'm very familiar with how difficult their jobs can be. But I'm also the mother of a young man that was killed by a police officer. And I can tell you that watching the video, yes, was difficult because we did eventually get to see the video. The family saw the video. It wasn't completely released to the public. It was released to a select number of media, which did then eventually go out to the public. And yes, it bothered me to see it, but not nearly as much as it would have bothered me to not know. And, you know, I listened to Representative Harrelson and him saying that we needed to allow the judicial system to do its job and that they would take care of this. And I believed in the judicial system. I didn't create a situation where we had rioting or a bunch of problems in Laramie. The ACOP group helped keep that settled down. We waited for the process. And I can tell you, this process is flawed. And there needs to be transparency. And you trying to keep these videos from being released just creates more distrust. This was flawed at every single level. And Representative Harrelson is going by the assumption that all police departments will go through their policies and procedures and do it the way that it's designed to be done. That doesn't always happen. And that part is the most devastating thing about my son's death, is all of the ways that this was covered up and not given what I felt a real honest judicial review. And that's caused my family, my community, all of us far more grief than seeing a video. We need honesty and transparency, and this bill is for that. And I strongly hope that you will move it forward. And thank you very much for allowing me to speak. Do you have any questions?
Well, Ms. Hinkle, thank you for sharing your story with this committee, and on behalf of the committee, I deeply apologize and sympathize for the loss of your son. And so sharing that story probably isn't easy. I have 3 kids of my own. I can't even begin to fathom what it would be like if I lost one for any reason on earth. So thank you for sharing that. Committee, do you have questions for Ms. Hinkle? Ms. Hinkle, I just have one question, and it's a similar question to what I asked Salvador. It doesn't sound to me like you had any nefarious purpose in requesting the video. It's your own son. It sounds like you wanted to see the video of your own son's death in order to understand it. What was your hope to have the video? What was your idea behind having the video?
Well, you know, I owned a small business for 32 years where I worked with police officers a lot. I had a lot of faith in the police officers. I wanted to know, you know, what did my son do wrong? You know, did he escalate this situation to a position that they really had no choice? It's not that I don't believe that there are great police officers out there that just have to do their job and they have to protect themselves too. That's part of the reason that I started CIT, was for the police officers, so that they didn't end up with injuries because they didn't know how to deal with people with mental illness. And so I wanted to know, you know, if he just really blew it, then I would understand that. And if he didn't, then I wanted to seek justice. But I needed to know. And I think the family members need to be able to know just what happened.
Thank you. Committee? Representative Provenza.
Thank you, Mr. Chairman, and thank you, Ms. Hinkle, for being here today and sharing your story with us. Did you have any opposition to the public seeing that footage, and how did, just in trying to get that, did that influence your experience with the justice system, given how you started with the justice system, working with law enforcement and where you are today. Thank you.
It had an extreme effect on me. It was released to this limited number of media without very much knowledge. So there was that, but then they refused to release it to the public, even though some of the media had gotten it. It didn't feel transparent. It didn't feel honest. And it just continued through that frustration of wanting to understand just what happened and to be able to move forward from there. And the only thing that it did was just cause more and more and more grief. You know, it wasn't having, I got to see the video. I did get to see the video. That trauma of seeing that video is nothing compared to the frustration of trying to get some transparency in my community. This was a system I believed in, and they destroyed it. I can't believe in it anymore. And I want it fixed.
Ms. Hinkle, have you had a chance at all to look at the bill that's before us? Are you familiar with it at all?
Just slightly.
I'm just
But
curious if you believe that this bill would have given you quicker access to the video of your son's death.
Yes, I do.
Thank you. Committee? Representative Grego.
Thank you, Mr. Chairman. Ms. Hinkle, just one question. Did you want the video released to you and the family or to the public as a whole?
I wanted it released to me originally, but yes, I wanted it released to the public as a whole. Absolutely.
You good, Representative Grego? Committee? Additional questions? All right. Well, Ms. Hinkle, again, thank you for sharing your story. We appreciate it.
Thank you.
All right, Clarissa, I suspect Mr. Barron's hand is raised. Anybody else?
Mr. Chairman, a couple other people have joined us. If they'd like to speak, if they could raise their virtual hand, that would be great.
Okay.
But yes, Mr. Barron has raised his hand.
And is the colonel in the room?
Yes, he is, Mr. Chairman.
Okay, while we wait for those other hands to come up, let's go ahead and let the colonel in. Colonel Howler, welcome to the Judiciary Committee.
Good morning, Mr. Chairman. Good to be with you this morning. Kevin Howler with the Highway Patrol. Mr. Chairman, if I may, I'd like to hit on a point of business this morning, and that is whenever this bill came to our attention, we were provided the opportunity to submit a fiscal note. And so just briefly, we believe as the bill is written today, with the short turnaround time of 72 hours, and I currently have a staff of 1 that performs these public information requests. We simply do not have the manpower. So we are looking at a fiscal note of 2 positions, additional software for redacting to protect the privacy of those not directly involved in incidents. And so we're looking at $105,000 to comply with that. And even then, I'm uncomfortable in that we would be able to meet the requirements as outlined today.
I have in front of my committee an administrative impact statement.
Okay.
And I don't have a fiscal. No. Is that still being prepared or?
No, sir, I don't, Mr. Chairman, I don't know what happened. I know that we submitted it and I read the same, I believe the same information that you have, but I do know that we submitted one.
Okay, well, because I don't have it in front of me, maybe I'll ask you just a few questions so that I understand it. So, two positions, those are FTEs,
Correct.
and what division would they be in?
They would be in our records division. Currently, our information, Public Information Act, we do receive numerous requests. Those requests continue to grow. We just provided one to an individual that had been stopped for speeding. And it took us about a month to gather that video together, the police report, and put it, everything to submit it to her, simply because there is a backlog, because everything, not everything, but many things are being requested.
Colonel, is your records division general funded?
No, sir.
So these are federal funds.
Mr. Chairman, it's a combination of federal funds, combination of fees and taxes via the highways.
Okay, so that would require a authorization to expend federal funds, but not what would be the expenditure from the general fund.
I don't believe that there would be any, but it would be from existing funds.
Okay, so to clarify that fiscal note, that is a zero cost to the state of Wyoming. That's existing funds, not an additional appropriation.
Mr. Chairman, it would be from existing funds, taking those funds away from other areas.
From highway.
Correct.
What is in the highway fund?
Mr. Chairman, you're talking about the value?
What is in our highway account? 6 billion?
Mr. Chairman, I don't know. I would have to get back with you on that.
It's been a while since it's been on appropriations, so maybe that number maybe has left my mind, which may be a good thing, Colonel. Okay,
Mr. Chairman, I don't know.
But okay, I think that's helpful though, because it sounds like it's no new appropriation, no general fund, existing highway dollars and whatever's in that account, which I think we can figure out. Maybe we could follow up on that. I think it might be on the fiscal note if I could find it.
Okay, if Mr. Chairman, if you do need assistance in that, I'd be happy to provide it to you.
Thank you, Colonel. I think Representative Washit had one more question, and then before we let you go back to your testimony.
Yes, sir.
Thank you, Mr. Chairman. Colonel, thank you for getting up early and joining us this morning. Could you kind of describe for the committee the range of video requests that you're receiving these days? What types of incidents? You mentioned a speeding ticket. I hadn't anticipated that. What other kinds of requests are you receiving?
Colonel, go ahead.
Mr. Chairman, Representative Washit, with the general public having access to technology, it is our assumption that if we're not recording the situation, someone else is. And so we make every attempt on enforcement action that contact, so to speak, is being recorded. So at the Highway Patrol, we currently have dash cameras, and they are mounted on the dashboard of our patrol vehicles. We do not have body cameras. But it's basically the same philosophy. And so information, evidence that is collected by those dash cameras is currently housed at each of the 18 divisions around the state. Ultimately, we do have antiquated technology at this point. Ultimately, is transferred to a DVD and then is housed at our headquarters evidence area. This particular incident that I was referencing, the individual had pled guilty and simply wanted the contact recording of that, including a copy of the citation as well as the incident report. And so all of that was provided. As far as the numbers have rapidly gone up, at least in the 5 years that I've been with the patrol. Last year, we provided approximately 3,200 public information requests. Now that's above and beyond and does not include what was provided to prosecutors' offices around the state for these citations, arrests, to be prosecuted in the 23 jurisdictions.
Thank you, Mr. Chairman. Just a quick follow-up, Colonel. You mentioned redacting. Can you elaborate about what kinds of things need to be redacted in some of these videos?
Mr. Chairman, and Representative Washer, you know, with being a part of government, we do have a responsibility to protect the privacy of those not directly involved, and so it does require some software that is generally considered an enhancement to the system, and oftentimes my experience is that the software blurs out the identity or the face of those individuals. And that takes time. I mean, to go through all that, and it's not just it's in its entirety. You have to go through the entire thing to capture that.
Yeah. So, Colonel, getting to the second part of your testimony, the first part was the the funds. The second part is, I think I heard you say you had some concerns with implementation, your ability to implement as the bill is written. Is that related to the FTEs, or is there something else in the bill that makes it difficult for you to implement?
Mr. Chairman, a couple of things, please. As I look through the bill, whenever I see inspect and copy, again, I would emphasize that we are talking about criminal evidence. You know, on the transparency side of the house, I've heard the testimony, and actually fundamentally, I agree with a lot of it. Transparency is important. Having said that, it's also a timing issue with that transparency, and these decisions aren't made in a vacuum. We are working with our attorneys regarding the dissemination or release of this criminal evidence. We're releasing with the respective prosecutors in each of the counties in the state, depending on what jurisdiction that this occurred in. In addition,
So, Colonel, let's take it one by one. So, with that one, when you say inspect and copy, is the issue copying the footage?
As far Mr. Chairman, it's a combination. Whenever we talk about in inspecting, in the most recent testimony I heard from Ms. Hinkle, I could see having provisions for family members to be able to see footage. As far as copies and disseminating, I believe that is a timing issue with the judicial process, because we are talking about criminal evidence. I'm sure Mr. Barron will talk to a fair and impartial jury selection for those criminal trials, and we're also talking
to do more and more with the internet. Eliminating copy would at least make it a little easier for your division, it sounds like. And to your point of the family member, I think that's really what lines 18 and 19 on page 2 is about. I mean, it can be broader, I suppose, but person in interest is really, that's defined in statute. And I don't have the definition in front of me, but I think, by and large, that's who we're talking about, right?
Mr. Chairman, thank you. I do agree to some extent. It would still require the redaction of those individuals that are not directly involved. But having said that, I do understand the other side of it with being transparency, with those family members of the individual involved. But I would also say that it is my job to also protect the officers involved. This is a tragic situation all the way around, including troopers, officers, and deputies that are involved in the event. So copies and things of that nature out to the public and having an open public trial, so to speak, I believe that the judicial process needs to run some of its course.
And that's an excellent point, Colonel, because I think, especially for some of our newer legislators unfamiliar with this law from 2017, there is currently a disclosure process, correct? Where we're modifying the disclosure process. It's not that there's not a 100% prohibition on discovery of this video, correct? Or
That
any,
is-
I should say.
Mr. Chairman, yes, sir.
So there already is a possibility based on existing law that the video could be discovered and disseminated onto the internet. We're just opening, the bill opens that door a little wider for people to get the video. It's not that the video is strictly prohibited currently from release.
That is, Mr. Chairman, that would be my interpretation of it. But as mentioned previously, we are coordinating with prosecutors involved as well. And predominantly because it is looked at as criminal evidence, it is being kept for prosecution.
Colonel, do you know if can the videos be copied currently, or that would, I think, be an addition? I think inspection is permitted. Copying probably through agency, I assume that the Highway Patrol can produce a copy to the district attorney's office to prosecute.
Yes, sir. That is standard procedure. Of course, that does take additional time, effort, and resources, but yes, that is being done.
Because when that occurs, Colonel, there's probably not a redaction, I would assume. On your end, it would fall on the prosecutor's office to properly handle that in terms of evidence and what redaction would occur. But your office isn't required to do a redaction when you send it to the prosecutor?
That is correct. It is the evidence in whole.
I see. So that really is, I think that's the big addition here, is that if we were to eliminate copy, then there's not a dramatic change in law other than now we're letting a family member inspect it in addition to a prosecutor. And that's where, and then the timeline. And that's the 72 hours.
Yes, sir. So currently, and we are undergoing implementing a new system. So I have great confidence that this will improve. But as I mentioned, currently we have servers at each of our offices throughout the state, what we refer to as divisions. So it can take some time to get those burned in that respective office, transported down, checked into our evidence facility. And so when I see 72 hours, it does cause some concern that our agency would be able to meet that turnaround time.
How much time, Colonel, would you need to turn it around?
Mr. Chairman, as I'm sure you're aware, currently in statute, we work with individuals requesting information. We're given 7 days to make contact and then 30 days to provide that information unless it becomes more difficult. That has been much more accommodating. Having said that, under this bill, when we are talking about the use of deadly force or lethal force, I definitely can see the need for the turnaround time to be less than 30 days. So I believe 72 hours is too short, but I do believe within 5 days that we could make that work.
Thank you, Colonel. A question from Representative Washut.
Thank you, Mr. Chairman. Colonel, if you know, how many of our, if one of the largest law enforcement agency in the state doesn't have the technology presently, how many of our sheriff's departments and police departments have the redacting software technology, if you know?
Mr. Chairman, Representative Washut, I apologize. I do not know the specifics of that, and I believe Executive Director Odakovan may be able to answer that.
Thanks, Colonel. We will maybe go to Odakovan on that question later, because I wonder just how many of our local police and sheriffs have body cams in general. So it wouldn't matter if they had the software because they may not have the footage, would be my assumption. But Odakovan, I'm sure, will have those answers for us. Representative Provenza.
Thank you, Mr. Chairman, and thank you for being here today. I have a question about how many of the requests that you get for footage involve fatal force or serious bodily injury, and how many of those do you believe you need, like percentage of how many of those need to be redacted? Thank you.
Mr. Chairman, Representative Provenza, thankfully, living in the great state of Wyoming, we do not have high occurrences of deadly force and or serious bodily injury. So I am thankful for that. But having said that, even though the number and it depends on the year, some years are higher, some years are lower. I have seen as many as a dozen a year, which I still think relative is fairly low. But regardless, we are still talking about criminal evidence and going through the judicial process, at least for the public dissemination.
Committee, other questions for Colonel? Representative Zwanitzer.
Thanks, Colonel Heller. Could you maybe, or Mr. Oder, walk me through how you know when deadly force or serious bodily injury has occurred? Do you have to wait for a prosecutor to make that determination, and then you can't request that evidence until they've been charged with a crime but not found guilty? I'm trying to figure out when the recording is actually available based on the statute. Do you make the determination if it was a serious bodily injury when someone is making a request, or is it only after it's become a criminal trial can someone request that evidence?
Colonel.
Mr. Chairman, Representative Zalmitzer, that is a very good question. Ultimately, typically what happens is my phone rings in the middle of the night. At that point, we begin an investigation. If it is deadly force or serious bodily injury, and that was on the reaction of a trooper, then at that point, the county attorney's office or district attorney's office is made aware. We then begin to provide information to that office. But to cut to the answer of your question, it is not me. It's not law enforcement that makes that ultimate decision. It is that prosecuting attorney that determines. And of course, it could end up before a judge for a probable cause hearing or in front of a grand jury to determine whether or not that will proceed with criminal action.
Additional questions for Colonel Haller? All right. Well, thank you, Colonel.
Thank you, Mr. Chairman.
Remind me who in the room wants to testify on this bill. All right. Mr. Oderkoven, let's go to you, just because your name was referenced maybe 4 times in the last conversation. I'm sure you have many remarks, but if you have any answers to the questions regarding number of local law enforcement that have body cams or access to body cams, if they have access to this software, if you would even know that, I think that would be helpful. And then I think we've kind of honed in on a possibility of deleting copying this from the statute. You probably agree with that. And we've discussed that 72-hour period. So if you have any comment from your folks on the 5 days that Colonel Haller referenced and the copying, and of course, anything else you want to talk about, Mr. Oderkoven.
Thank you, Mr. Chairman. Byron Oderkoven, the Executive Director of the Wyoming Sheriffs and Chiefs. First, let me offer, this is a very serious topic. It's a very emotional topic. It's a very sensitive topic to those that are involved. And I feel for the people who have gone before me in testifying as to the trauma that they as family members hold. So it bears to mind or brings to mind that this topic was the subject of an interim study. We spent the better part of 2 years arriving at the point where we are now, with a discussion of court proceedings, timeliness of evidence, actual availability of body cameras, the processes by companies, the cost to agencies, the likelihood of having cameras. We covered all of that over a 2-year period, and now we're making a significant modification, or the bill before you is a significant modification, which was discussed and rejected during that interim discussion by members of the judiciary before. So I think it's important that this go very slowly because this will make a significant change into the work that was done before and have a significant impact on court costs and agency costs as well. Having said that, let me start with answering the first part of the question. So when the bill was first contemplated, we were told that the largest agencies in the state would probably not proceed with having body cameras because of the cost. It is not the cost of the camera. Actually, the cost of the camera is going down. It's the cost of storage, retention, the retention from the standpoint of what is meant for the state statute in records retention and the state archives rules, and likewise for court proceedings, especially in the area of serious bodily injury and deadly force. That has significant time windows of both criminal prosecution and the follow-up civil cases that come to pass. So the costs involved for agencies was significant. In fact, I would have to go query my members, if you would, to how many have overcome that, or if the cost, is my understanding, the costs have continued to escalate. The cost of, I think I'll answer the next question.
On the number? I mean, I think so it doesn't get lost in the testimony. I think that that's important because when you referenced in your testimony a cost to agencies, and we discussed with Colonel Haller, the cost to his agency. I think now what you're referencing are the local police and sheriffs. And so to truly understand the impact, we would have to know if only 2 local agencies have body cams and they each have 2 cams, or there are 100 cams and 20 agencies have them. Those are very different things. So if you have, it sounds like you have to survey your members to know exactly what we have. So we really can't, and I appreciate that there would be an impact, but we don't know what that is without knowing how many actually have body cams, right?
Mr. Chairman, for further clarification, with the budget cuts, it is a cost of local cities, towns, and counties. You are correct. The purchase and the contracts with the provider. The provider, generally, these are stored in the cloud. The Colonel referenced one of the first methods of doing the cameras, and that is to transfer the information from the dash cam to the DVD for physical storage. Generally, the process has gone to a cloud-based storage with an additional cloud-based cost. Those costs have risen to the point that some agencies have said in the budget reductions, they will stop doing that because that is an additional cost above and beyond the actual delivery of service. Carrying on, the cost of redaction is generally on a case-by-case basis as the contracts go. So the more requests, the more the cost. The greater the cost, the greater the likelihood that that will be a budget reduction item at some point. So there's a slippery slope in there that I want to paint before we get to the actual issue of the bill, that those costs are driving some of the decisions by local cities, towns, and counties to actually implement body cameras or to continue based on the rising cost of the service.
Representative Washit.
Thank you, Mr. Chairman. I just want to emphasize, Mr. Odekoven, you mentioned dash cams. The chairman's mentioned body cams. Both are included in this bill, correct? And so there'd be more agencies with dash cams. It's older technology. I think, we had dash cams before I retired, not a long time ago. So dash cam recordings have been popular for a longer period of time than body cam. So agencies that may not be doing body cameras may also still be doing dash cams. Is that correct?
Vice Chairman Washit, is that back when they just took those video recorders and taped them to the dash? Those big.
We strapped ours around the neck of the horse.
The horse, that was it. Yep. Mr. Odekoven.
Thank you, Mr. Chairman. And yes, the technology's evolved. In fact, I'm aware that a couple of agencies have transitioned from dash cameras to body-worn cameras, and a couple are actually pondering going back the other way. The dilemma that you have with a dash camera, of course, is it only points in the direction of the patrol car. So if the patrol car is parked eastbound and all the action's taking place westbound, you may have sound, but you certainly don't have any pictures to go with.
And that's
Um,
why I didn't reference dash cams, because they seem like they don't catch the most of the footage that we're talking about. But how many cases in the last year, how many requests were there in the state of Wyoming for body cam footage?
Mr. Chairman, I would hazard to guess at that, and I'm not, it would take a little, I can certainly ask the members for a anecdotal number, but I'm not sure I would come up with a very accurate number of the actual total of number of requests for release of information in that regard.
And I'm not talking about just a broad release of any information, but very specific to honing in. We're talking about an incident of deadly force or serious bodily injury. So not a fender bender. We want to know, someone requests, but serious bodily injury seems like you just tested. I think one was Colonel Haller who said we don't have a lot of that in Wyoming. Venture to be less than 10.
Mr. Chairman, I think that would be a good starting number. I think it's important to realize that as we visit about this, that you seem to have a couple of different things, and I'm not sure that the bill properly describes, because we're also being inundated with requests for video for every high-speed pursuit, every sexual assault, every interview. We're getting requests from colleges all across the country. If only we would look at all of your camera footage, we would be able to help write our master's thesis on you pick a topic. Freedom of information. We want all of your high-speed chases so that we can put it on the HBO series on positive police pursuits. We are inundated with requests to accommodate that. And this bill contemplates that we would accomplish that in 72 hours or 5 days, as opposed to the 7 and 30 now. And the potential for a court hearing, whether we would determine the applicability of that release. I think part of that is then removed. So this would have a significant change in part of that process, let alone the discussion of evidentiary.
Representative Williams.
Thank you, Mr. Chairman. Mr. Odekoven, you mentioned earlier there was an interim study that was conducted. Can you tell me what year that was?
Thank you,
Go
Mr.
ahead,
Chairman.
Mr. Odekoven.
That was when we were referencing the bill that was created in 2017. So that was the previous judiciary, if you will, for the 2 years prior that worked on the language in the bill, the statutory language that is before you.
Almost previous judiciary. It was right before, I think it was right before Representative Washit, during Representative Olson's early time.
Mr. Chairman, I was looking around thinking the same thing, as there was nobody here that was part of that discussion.
It's a little different committee.
Mr. Chairman, may I continue?
Go ahead, Mr. Odekoven.
Thank you. So in terms of, I'm very disappointed listening to the testimony this morning that what we contemplated for a proper procedure for the custodian of the record to communicate with the county attorney's office for that opportunity for the release of the evidence. And if there's an issue, to go before the judge to determine that so that it can be dealt with one way or the other. I'm very disappointed that that process that we contemplated being clear in the bill is not being followed. Now, having said that, I'm not sure that the remedy is to then make it faster and easier sooner, or do we need to review the statute to ensure that folks are following the existing law? Because I'm reminded that these cases are a criminal case. So are we suggesting in this process that we would, for serious bodily injury and death, that we would be releasing to the public video footage of dash cam, body worn camera, or other evidentiary out to the public before the decision of prosecution or civil suits or remedies are completed? That is very troubling for both. It would be a very interesting divergence from our current processes to ensure juries aren't tainted by everyone viewing, and or the court of public opinion becomes the court of jurisdiction. Is a fascinating venture and trail to start down. So I would like, Mr. Chairman, with all due respect, I would hope that we would look at the statute from and take in the testimony and look at where did the current statute fail and how best to fix that failure, rather than open up a whole new section that requires some shorter time windows, some copies, some dissemination, some public releases of information. And it's not lost that in the initial review, it was anticipated that all the video camera footage would show that officers were doing things incorrectly. That was part of the testimony. They were hoping to have the bill on recordings offered so that we could find the police misconduct and identify it very quickly. In law enforcement, we're anxious to have the video released because it does just the opposite. In fact, generally speaking now, for a DUI case, for example, the first words out of the defense attorney is there a video? And if the answer is yes, when do we plead is usually the next comment that's done. Because the video generally shows clearly, whether it's dash cam or body worn camera, the crime of DUI as presented. So now granted, our discussion today of serious bodily harm and death is a slightly different discussion. I'm just saying that the CSI effect is clear. If you have a video, it happened. And if you don't have a video, it didn't happen. And I would remind that in terms of video or photograph or other evidence, it is the officer's testimony that is first and foremost, supported by the video, albeit the car might be pointed east when the action took place west. They may hear part of the conversation, but it's the officer's testimony that is to carry the day in that regard. The video, unfortunately, as you see on television, or as we've seen from the bank robbery photos or the whatever, is usually not as clear as we would like to make that total understanding of the totality of the events in that little snapshot in time of that video and that photograph.
Yeah, Mr. Odakoven, I kind of hearing two different things from you. So, and I like the first thing I heard, because the first thing I heard was that as we listen to the public, I feel like you're recognizing that maybe this is a new statute. We all know that. We put this in place in 2017. I feel like what I heard is a recognition that we may have some issues with the statute. This bill may not be the vehicle to fix it, but there are some issues that we can work on to fix it, which I appreciate. It's much different than hearing we're here to solve issues, right? And we have public testifying there's issues, and then if we just all say there's no issue, I mean, I think we're at the point where at least we know there's some access issues. The question is, how do we solve those access issues? The second part is a whole nother conversation on whether body cams are good evidence or whether they mess up juries or whether they really tell us anything. And I think that's a whole nother conversation, right? But if there is an issue to solve, well, it sounds like you want to spend a whole interim with us again, because if this isn't the vehicle, what gives access to these people that we heard from? Because these are our constituents. And that's Representative Harrelson's constituent who just testified. That's Representative Provenza's constituent who just testified. So we got real people with real issues coming to us and saying, help. And that's our job, right? And so trying to work with the colonel on figuring out what helps this work in his agency. If it's not if this isn't it, what do we do?
Mr. Chairman, thank you.
Odakoven.
Thank you, Mr. Chairman. Let me react in a couple different ways. I would guess, first, I would suggest that if we're looking at a fix to the current statute based upon the need, the question before you is, does this in fact do that fix? I would offer that it may not. I would offer that we may need to look at the custodian of the record, the role the county attorney plays, access to the court, whether the judge has ruled, and in fact, in the examples given, were any of those processes followed to boot? I don't have any understanding of that or clear evidence of whether that happened. Did everyone involved follow the existing statute, or do we want to make it easier and faster, irregardless of the existing statute? And that's where I think your role, and please, I don't mean to offer, is a fine line and a balance in there for is the issue before us solved by this statutory change, or do we need to fix another piece of the statute to make it clearer to the parties involved how this statute is to work? And again, I'm disappointed based on my understanding of the statute that it didn't work for these folks.
Thank you.
Mr. Chairman, questions for me?
Additional questions for Mr. Odeko? All right. Thank you, Mr. Odeko. I lost Representative Clifford. I'll have to apologize to her. And Representative, well, but I think Representative Worf is here for his bill, which is next, I promise. Okay. Mr. I think in Clarissa, in the virtual world, I think we have Mr. Barron. Has anybody else raised their virtual hand?
Mr. Chairman, at this time, I do not see anyone else who has raised their hand.
All right, Mr. Barron, come on in. Mr. Barron, we'd love to hear from you. I know you've been listening, so I'll say kind of same little bit of direction I gave to Mr. Odekoven, and that just is, try to keep us centered on where we've headed with the conversation, and so we don't get, sometimes we get lost in testimony, but please share with us whatever you'd like to share with us.
Thank you, Chairman Olson. My name is Joseph Barron. I'm the Crook County and prosecuting attorney in Sundance, Wyoming. As I've stated earlier, I've been doing this criminal prosecution since 1986, and I've been the elected county attorney there since 1990, taking office in 91. I speak on behalf of the County and Prosecuting Attorneys Association, who is opposed to House Bill 213, the disclosure of peace officers' recording as it is written, because it interferes with legitimate law enforcement investigation and criminal prosecution to find the truth and provide justice. To answer some of the questions here, if one looks at the definitions, as I have had time while I've been waiting to get here, is that the law pertains to video and audio recordings, which is something that exists not so much anymore, but we have both there. One of the things that I sense overall to the committee is what are the policy considerations? Because there is a bigger picture, as Mr. Odekoven revealed, and as I've thought about this with what's been going on, what are the policy considerations here? They're the defendant's right to a fair trial, the state's duty to prosecute, the public's right to know, and the victim's rights in these matters. Under our current system, and I'm neither for nor against the current system, but just the way it is right now, is that's the order in which rights and considerations are given. The defendant's right to a fair trial, it's a constitutional right. The state's duty to prosecute as the executive branch of government, the public's right to know, and finally, the victim's rights. The problem that we've heard today from the folks involved here is victims' rights seem to be the last get put on the back burner and pushed aside so that these other considerations can be taken care of first. This bill, and I have to say, in dealing with victims all the time, I truly have an issue and a problem with that. And I do think that victims' rights need to be greater or equal to the rights of criminal defendants. How we get there and provide all those other competing policies doesn't happen with this particular bill. The bill has a potential to force the revelation of information that should remain confidential until the investigations are completed and the criminal justice system has run its course. This will ensure that the victim receives justice and defendants receive a fair trial as guaranteed by our Constitution. In this matter, criminal defendants have legal access to evidence against them through the rules of criminal procedure, federal and state case law, through the discovery process after they are charged with criminal charges. My failure to provide discovery and exculpatory evidence to a defendant may result in my losing my right to practice law. All prosecutors take these matters seriously. The problem with this bill is that in the name of transparency, it will take witness statements and evidence presented and the apprehension of fugitives. Make no mistake, once the video is released from law enforcement, it will eventually make its way to the press. And when I talk about law enforcement, I consider myself as part of that process. Video and audio recordings are only a part of the investigation and usually cause more questions than answers in most cases. That's my experience. A body camera is not a widescreen TV camera that includes what the officer sees. It only includes what the camera sees when the aperture and other settings that don't match what the human eye sees. If your goal is truly transparency, then you could live feed every officer. And if your goal is justice for your community and the subjects of the recording, then at least treat it like any other piece of evidence that is not released until the investigation and the prosecutions are completed. Now, recently, what we're talking about here and what I've heard the folks talk about here and seems to be the issue, and it is an issue.
Hey, Mr. Barron, sorry, can you drive us home?
Yeah, I'm going to tell my story, Mr. Chairman, and I think this is important.
Well, Mr. Barron, I appreciate that, but I do have time constraints. I only have so much time to hear all the bills, and I afford everyone an equal opportunity to speak. Absolutely, I don't afford everyone to have unlimited time. They did the same thing with every witness. I've been clocking it now at the longest testimony. So I'm just asking you to drive it home, bring it home in a minute. That's all I'm asking.
A minute?
Yeah.
Well, Mr. Chairman, recently I've been involved in an officer-involved shooting where I watched the videotape it. It takes more than 72 hours to investigate this matter. If you release stuff within 72 hours, that's going to interfere with investigation and prosecution. That's a simple matter there. If we get down to the bill, the other problems that you have with the bill are these. If you look at the statute as written, let's look at that statute as written. The first thing it says, who's the person of interest? When you look at the definition that's in the statute under 16.4.201, the person of interest means the person who is subject of a record or any representative designated by the person, except if the subject recorded as a legal disability, dependent high school student of the parents. A person of interest means the parent or representative. In most cases with an officer, in some cases with officer-involved shootings, the person in interest is dead. They cannot designate anybody. And so what happens as a practical matter, what happens in those cases is you have various family members that come in and they have some want it disclosed, some don't want it disclosed, some from a prosecutor's point of view, trying to figure out how are we going to release this information or show this to the family or how we're going to do all that. The statute does not answer those questions. You know, does a parent get it? Does a cousin get it? Does the siblings? Does a step siblings? Frankly, the statute is very lacking in any direction on how that goes. The other thing with that I believe the statute was cured on page 2, line 8. There's no such thing as C2. There's no such statute in there. Page 2, it referenced D1 and D2. They're irrelevant. The other thing is it talks about on page 2, line 11 through 15, on that, there's no definition of public agencies on that. And so what does that mean? And who's a public agency in that particular matter?
And Mr.
So-
Barrett, just maybe to help you out, we have a statutory definition for
No,
agency.
where's a public agency defined?
No, that's in Wyoming. That's a general statute in Wyoming law, I believe. So we defined that. I don't have the statute off the top of my head, but I know in our green books, there's a definition of that. We defined that long ago. I think it might be in Title I.
Well, in any event, it's not.
any
in this
event, we can-
particular-
Maybe
this-
it's Title IX. We can circle back, but not every, I mean, every bill, every section, there's a lot of general definitions in Wyoming law. Agencies is one of them, I believe. But thank you. And I appreciate that on the line 8. Oh, it's, what is it?
Well, 16.4 is public meeting, so it defines agencies.
So 16, just off the top of our search, 16-4-402 has a definition, for example, but I appreciate you pointing out the sub or the paragraphs C, Romanet, II and DI, or we'll definitely take a look at those. If they're not applicable, they're not applicable. Representative Provenza?
Thank you, Mr. Chairman. I submitted an amendment yesterday to clarify that language because
Oh,
when we moved
perfect.
it around, it was a typo. So what the line will say now is after 2 on line 8 of page 2, we will hopefully this committee will amend to strike everything from paragraph on and insert Wyoming statute 16-4-202 subsection C Romanet 2 and subsection D Romanet I and Romanet 2, sorry.
Great.
So that will.
So we got to clean up amendment to cover that. It looks like, Mr. Barron, our legislative process is fast and loose, and I go to bed at night worrying about our staff and wake up worrying about our staff. And I get emails from them at 11 o'clock at night and they're still drafting, and God bless them for trying to put these things together as fast as they do. And we catch things as we go and clean them up. We appreciate you pointing that out to us as well. That's what we really value your testimony for, is the ability to help us make bills better where we can. It's very valuable. Questions for Mr. Barron?
I'm not done testifying. I have one other thing that I want to comment about, please.
Well, I'm sorry, Mr. Barron. I asked you to wrap it up in under a minute. Can you give that to us? And I was very generous with that minute. And I really apologize, Mr. Barron. Maybe it's that you're newer to the process, but we only have so much time in a day to hear so many bills. And so everybody wants to testify. We let them in. What I don't do, what a lot of committees do, is set a time restraint, 1 minute, 2 minutes per person. I don't do that. Let everyone testify, but your testimony is becoming lengthy, and that's a reoccurring thing. I think if you want to help us, and we want you to help us, just try to be cognizant of time. There's this is an entire process with limited time. That's all it is. It's not, it just is what it is. And I apologize to you, Mr. Barron, that happens, but that's just a reality of time. So if you want to wrap up, I'll give you one more chance to wrap it up in 15 seconds. But if you prefer in the future, I can just set time limits.
I would prefer to know what my time limit is, Mr. Chairman. And then let's keep everybody else to them as well.
Okay, when we can certainly do that.
But it's up to the Judiciary Committee to determine, and you to decide what you're going to hear and what you're not going to allow to hear. I just wanted to say that this law change allows an officer that has been accused of shooting someone, because the other definition is he's also because it doesn't really say, it says subject of the recording. So the officer that took the thing, he's subject to that. So now he can get that information prior to the time that he's interviewed. So he has a chance to conform his testimony to what he sees on the video. This taints his state of mind and avoids seeking the truth and getting the truth. This may deny justice for the victim and or the officer in the particular thing. So prosecution needs to run its course just like any other evidentiary things, and it needs to be there. If you want to fix this thing, what you need to do for victims, and that's what I hear you saying, is that you want to fix it for victims, is give victims rights and the victims' rights to do that.
Representative Washington.
Thank you, Mr. Chairman. I personally value the testimony of the Prosecutors Association. I think it's very important for us to have that perspective. And I just recognize that we do have limited amount of time, but encourage Mr. Barron that you can also submit written testimony and email that, and the Judiciary Committee can access that information as well. And that sometimes speeds up the testimony in these proceedings. So I just encourage you in the future, maybe fire us off a lengthy email and we can read that in addition to what you have to say in the committee.
And thank you, Vice Chairman Washington. Two other pieces to that pie. Another is handouts, Mr. Barron. Example, I believe a bill that you were listening to yesterday, we had a half a dozen handouts on our desk, and not all of those people testified, but they had their names and their testimony on the handout. So another method to get information in front of us. So please use all of those avenues to get information in front of us. Obviously, as you know, as a lawyer, you submit so many things to the court. A lot of that's written. Sometimes you get oral argument, and then you get time constraints on that. And maybe the court does a better job because they set those constraints early on. But one other thing, and this is just on behalf of the committee, one request I would have of your association, and I'll just continue to ask for it, but I think it would be really helpful because I do value hearing from your association. What would be really, really helpful is, because your association is involved with these bills, maybe try to get your members together and take a vote like you did on all the bills and send it to us in advance. There's associations that do that. Man, I love our County Commissioners Association is here today, because that's what they do for us. They send it to us early in the session, and we can, throughout the entire process, we can scroll through and see any bill that they believe affects them. And they do it for every single bill. So even a bill that doesn't, they have no position on, they say no position. And, I'm not telling you how to run your association, but man, is that helpful to just, so we don't show up in a committee and then it's just bam, my members voted and we don't like it, or my members voted and we love it, or my members haven't voted yet, but here's my thoughts. But man, if we could have that in advance, it would be really, really helpful to know where your association stands on all bills that you believe affect your association or your industry. So I do value that, Mr. Barron.
Mr. Chairman, I've been doing this probably longer than you've been in the Senate. I understand all the things that you say.
I would agree with that.
If you would, and appearing before committee hearings, I know that things can be in writing. Frankly, if you want that to happen, please appropriate a couple $100,000 to the County Attorneys Association so that we can hire somebody to do that work. We have jobs to do. We take away extra time to do this. Most county attorneys are not somebody that sits as an administrator. They have a caseload. They can't be here because they're in court, because they're working. And so in order for us to do that, and we recognize that as an association, that we need to have money to hire personnel to do that. WHAM has that. The County Commissioners Association have that. The sheriffs and chiefs have that. We don't. And until such time as that funding is made available, then that frankly is not probably going to occur.
I'm okay, Mr. Barron. Thank you. And I'm sorry. I didn't mean to take us down that trail. I was just trying to be helpful. That's all. I'm sorry. But
No problem.
let's get together. And if there are some issues, we can work outside of the committee time on some issues in terms of getting that information out to our members. I'll do my part and try to make timelines more clear in the beginning. Thank you, Mr. Barron. Questions for Mr. Barron? All right. Thank you, Mr. Barron. Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. As I look at this, public access to things like body cams or dash cams or whatever is public access to what I consider to be a consummately public act, exercising the power of the state. The public ought to have access to it. I had a drill with a service improvement district where I requested to review their district records. I'd have been very happy if they'd have just piled them in the center of a big table and let me look through them. 16 months violated statute. At any rate, the point I would like to make to you is there needs to be some sideboards on what's released to the public. You heard Colonel Haller talk about that, and I'm sure some of the sheriffs and chiefs of police would talk about it. And here's what I'm looking at. In my experience in the Navy and the submarine world, intelligence world, we collected it and so on. You would be surprised at how much information can be gleaned from just looking at normal routine operations. And when you get into things that are quite dangerous, the drug world and so on, there's perhaps even more. I would call your attention to the Walker case, the espionage case of the mid-'80s. And what that guy did was give cryptologic access to routine submarine force communications. And there was very clear evidence that the Russians learned a lot from that. And so as you look at that, as you look at what you're going to release, how quickly you're going to release it, and so on, I think you need to give Colonel Haller and your sheriffs and chiefs of police room to make decisions about what gets released. And you need to give them time to do it because there's a lot of information there. Like I said, if you just observe routine public access or routine operations rather of what they're doing. As a side note, you talk about who do you release it to? Certainly a citizen or a news media in Wyoming should get stuff. If somebody from outside, Mr. Erdekoven spoke about people writing doctoral dissertations, they ought to have to pay for it. Subject to your questions, thank you very much.
Questions for Mr. Winnie? Always appreciate it, Mr. Winnie.
Thank you much, Mr. Chairman. I do appreciate your words yesterday. Thank you very much.
And we appreciate you traveling all the way over here to testify. Clarissa, anyone else in the virtual world who has their hand raised that would like to testify?
Mr. Chairman, I do not have anyone else on Zoom.
Thank you. How about in our room? Anyone want to testify on this bill? All right. We'll close public testimony. Committee.
Move the bill.
Moved by Representative Yen, seconded by Representative Provenza. Amendments or discussion?
Mr. Chairman.
Representative Yen.
Yeah, so I think we've heard from quite a few people today that the current process doesn't really work, unfortunately. And I think there was also concern that, maybe this is a lot at once, but I think we need to do something, right? So I don't know if I will be the one to make restrictive amendments, but I think some of the suggestions provided by Highway Patrol, et cetera, are worthwhile to make this a little bit more of a baby step than the full-blown thing. But I think we do need to make some changes to the statute now to make sure that we have more transparency in our justice system. I will make one amendment.
Can I respond to that?
Sure.
Representative Yin? Because it's kind of where I'm at, is I listen to the testimony and I hear from Colonel Haller and I hear from the association representing our police and our sheriffs, and I hear from the public, and I hear from our prosecutors. That's the stakeholder universe that we're talking about, right? But what I love to hear in the legislative process that I don't hear right now is consensus. What I do hear is that there's an issue. I think that's what I'm hearing. There's an issue. And this is a new law in 2017. And the question is, what is the fix? And is this the fix? I don't know that we have the consensus that it is. I don't know that we have all the data and the testimony that it is. Obviously, quick access is one issue it appears we're trying to fix. Who has access is apparently another issue. Budget issues, things like that. I certainly will leave this to the pleasure of the committee to amend it and work it as you will. From my perspective, listening to the testimony today, I know we're on the motion to move the bill, but I wouldn't have been opposed to laying the bill back and considering the bill as an interim topic, because I think that it's absolutely relevant to have the prosecutors at the table building. I was there in 2017 as we built the statute, and I wasn't an integral part of it. I was a new member, but I watched it being built, and I watched these stakeholders work for over a year, to build it. So I do appreciate that as a reality too. And I'll just throw that out there to the committee. If this goes to a vote, I'm obviously going to vote for this bill, because I agree with what you said, Representative Yin, that if we are to amend this down to some small fixes, I think that we'll at least move the ball. But I'm interested in looking at our almost 4-year run with the statute and seeing, are we doing it right? What can we do to improve this statute? That's exactly what this committee is designed to do, is create a law and put its thumb on the law and follow it to make sure it does what it's supposed to do for the citizens of Wyoming. So those are my 2 cents, and very much in favor of I guess either path the committee chooses. Representative Yin.
Mr. Chairman, I think if that's the pleasure of the committee, I would be happy to see it as an interim topic. So I will withdraw my motion if it's okay with the second, and if there's no objection from the committee.
I just have a quick question.
Representative Provenza.
If we were to move a bill, could we not do an interim on it?
So it's a really good question. So there is no guarantee that anything becomes an interim topic at this stage. The process for something to become an interim topic requires the chairman of the Senate and the House Judiciary to prioritize the topics that are submitted by the members. So anyone can submit a topic to the committee, but ultimately, currently, under current process, the management council, the legislature decides which topics the committees will study. So it'd be up to management council to approve that. Unless a certain said bill were to pass, but there's a bill that would amend that process. Representative Washington.
In the interest of time, Mr. Chairman, I'd like to make a motion that we postpone this bill indefinitely.
Well, there is a motion on the table. Well, the second hasn't withdrawn it yet. Okay, so a motion to postpone indefinitely is debatable, actually, but we've already had some discussion on it. Is there additional discussion on the motion to postpone? No. And to clarify this, because I had some questions asked on this before, motion to postpone indefinitely is not a roll call vote, because it is not a motion do not pass. A motion do not pass would be a roll call vote that would go out to the body with our recommendation that it do not pass. A motion to pass with a failed vote goes out to the body with a dead bill. But a motion to postpone indefinitely means basically it's laid back on the table. It remains in my drawer. I can also bring it back out of the drawer up until my deadline expires, just so everyone knows how that process works. All right, ready to vote on the motion? All those in favor to postpone? Those opposed? All right. That is postponed. All right, next bill for our consideration, House Bill 116. Representative Wharf.
Mr. Chairman, members of the Judiciary Committee, Representative Wharf, got a pretty simple bill. I can find it now. We have before us today House Bill 116. It's concealed carry residency requirement. And the purpose of this, it's really pretty simple. It just is to expand the constitutional carry that we passed to include U.S. residents. Wyoming is the last state that has passed the constitutional right to carry, what we've always referred to as constitutional right to carry bill. Wyoming is the last state that's done that, that's now seeking to extend that to all U.S. residents that fit the definition. So if you want, Mr. Chairman, I can read it. It's a pretty simple bill. It just goes in, like I said, it's an act relating to concealed carry weapons, removing the state residency requirement for a person carrying a concealed firearm without a permit who meets the other statutory criteria, and providing for an effective date. So it goes into statute 68-104, and it adds this under section A, subsection 4. It just changes and puts in is a resident of the United States. And then it changes the subsection B, I to B section double I, Romanet I, double I. So with that, if there's any questions, like I said, it's a pretty simple bill. It's just expanding that to U.S. residents. So if there's any questions, try to give you back some time.
Thank you, Representative Wharf. So to clarify that, because this, I've had some emails from my constituents who say, I think I like this bill. I think I'm in favor. I just need to really understand what it does, because the concealed carry statute, as you are well aware, is written in the negative. It's kind of the reverse.
It's a little backwards.
So this feels like it's backwards, but correct me, I want to make sure I'm reading the bill right. Okay. So what this does is say you must have a concealed carry permit. That's subsection A, unless, and then here are the exceptions. So then the exception the exception becomes constitutional carry.
Correct.
In Wyoming, which is any resident of Wyoming right now. And so what this does is say it's really saying that any non-resident of Wyoming, any person in the United States who is a resident of the United States can now constitutionally carry within the state of Wyoming.
Correct. And that's it. I mean, that's the term that we would probably use is if you're not a resident or a non-resident, that you would be afforded the same thing. And this is really important when you think about tourism. I know there's a lot of people that travel. There's a lot of people that like to be able to travel and know that they can do so safely and without worries. I thought this was an interesting guide. I don't know how many of you've seen this, but this is a travel guide that's put out. It's put out by, I don't know, can we mention names? I don't know.
You can mention proper names.
He is an attorney from back east. I can't remember what state he was from, but it every year he puts this out and it updates it. But people are obviously, they love to come to our state. They love to come to our state because we do afford, those constitutional rights. And this is something that
by extending this to those people, I know it's going to be well received. But that is just for clarity, that is really all this is doing. And one thing that you do need to understand, because I didn't know this, that somebody that has a green card, according to the federal statute, is also considered a resident by federal law, just so the committee is aware of that. So,
And that is helpful, Representative Worf, because I've received that same question. Is this talking about is it addressing foreign nationals in our country that may not be natural citizens, but that has really nothing to do with this, because it's about a resident, which means you're physically in the state, have an address.
Yeah, and so somebody that is here that has a valid green card, they are, according to the federal statute, the way I understand it, they are in fact afforded that same right, because even though they're not what we would call a resident, the green card status does give them residency in the U.S.
Vice Chairman Washit.
Thank you, Mr. Chairman.
Representative Worf, welcome.
Thank you, sir.
You mentioned that we, of all the constitutional carry states, we're the last one to consider this bill. How many other states are there that have already done this? Do you know?
You know, Mr. Chairman, I don't know. I know at one time it was around 15. And I know the last state that did it was Idaho. Idaho was there was two of us, and Idaho, I don't know if it was this year, or if it was last year when they did it, but I know Idaho did it just before. So we are the last of the states, but it seemed like to me, Mr. Chairman, that we're right around 15 states that have passed the constitutional right to carry. And for those that don't know, it says that if you're a person in good standing, that you can have and own a firearm, that you aren't required to have a concealed permit, that just the fact that you're a law-abiding citizen, that's afforded to you. Any other questions, Mr. Chairman, or?
Representative Swan, sir.
Thanks, Mr. Chairman. Representative Worf. So explain to me the process now. So if I'm from another state that doesn't have reciprocity, right? Because we do have that if you are another state, you have reciprocity with Wyoming. But if you're not one of those states, what would be the process to concealed carry in Wyoming? You have to go get a concealed carry from our state? You have to get, how does it work?
No, Mr. Chairman, what this does is this extends that constitutional right to anyone. So a concealed carry permit is no longer required for any, if this passes, would no longer be required for any U.S. resident. So if you can legally own and possess a firearm, you can conceal carry in the state of Wyoming without any permit. So is that clear?
Mr. Chairman, I got that, but I guess my question is, so what do people do now? They just aren't allowed, so they either wear it openly, or they have to get a permit, or they leave it in their vehicle?
Correct, Mr. Chairman, that is correct. The current process, if you were a non-resident visiting this state, you could open carry, because that's something that we also afford. That's a right that we recognized. Otherwise, if you are concealed carrying and you're not a resident, you could be subject to fines. But I would imagine, most law enforcement guys, you're a law-abiding citizen, they're probably just going to tell you, don't do that, put it in the car, whatever. But this really removes that. So it's no longer a question. If you can legally own it, you can carry it. So.
Sorry, I was trying to light my mic. Representative Provenza.
Thank you, Mr. Chairman, Representative Worf. I just have a question, and I apologize if this has been asked or answered while I was collecting my thoughts from the previous bill, but on line 12 or on line 13 on page 2, you cross out subsection BI. Wait, I think I mixed up my thoughts. I was thinking AI, subsection AI, which would have eliminated peace officers from allowing to carry.
Yeah, we wouldn't want to
concealed
do that,
weapons.
Mr. Chairman.
So
That's
I
just
withdraw my
Yeah,
question.
that's just a renumbering.
Thank you. My apologies.
Representative Ian. I'm just going to leave my mic lit. I don't know. It's not.
Mr. Chairman, thank you. Representative Worf. So I mean, my question is actually on BI. So we're doing this in AI, which basically divorces it, well, AI for A4, which divorces it from BI. And so my question is, why don't we just do this in BI, where we just strike has been a resident of Wyoming? So if you wanted to, you could also get a card or not have a card, wherever you are from the United States. I don't understand why we would separate the requirements for getting a concealed carry card versus not having to need a concealed carry card. It just seems simpler that we would do it in BI than AI. So I guess my question to you is, would you be opposed to doing it in BI?
Mr. Chairman, I'm assuming that LSO drafted this. I mean, they're the ones that came up with this. I'm assuming that this is to standardize it. The other states that have given this, I don't think they require any type of a permit to be carried at all. And that's kind of the purpose. I think, is that the question, Mr. Chairman?
Mr. Chairman, Representative Worf. I mean, I guess without having the statute in front of you, so A talks about being able to conceal carry without a permit, and B talks about what it takes to get a permit to conceal carry. And so by default, A just allows you to do, A4 essentially allows you to do conceal carry as long as you do all the things that are required for a permit. And so where it strikes out BI is the part about resident of the United States and resident of Wyoming. For me, it just makes sense to make it so if you want to get a concealed carry permit or not get a concealed carry permit and conceal carry, we should just have the same requirements rather than require you to be a resident specifically for you to get a plastic card. That's all, Mr. Chairman.
Representative Worf.
Yeah, and Mr. Chairman, I'm just trying to read the statute. I apologize, but I believe that it's just they put it under BII, and they've struck the BI. I think it's just it's no longer required. I mean, it's just it makes sense to me that that's where they put it. But
So it looks like, so I'm just trying to catch up on, because I pulled up the statute. So it looks like what happens here is it says the person does not possess a permit, so we don't care that they have a permit. They are a resident of the United States, and they otherwise meet the requirements specified in B2. B2 is that they're 21 years or older, right?
Yep.
So we're just saying, start with B2 and then go through. All we're saying is they're
21.
They're 21. You go through the rest of this. They don't suffer from physical infirmity, handling a safe firearm, is not ineligible to possess a firearm pursuant to the federal statute, has not been. And then there's a list of some, time in a federal facility and Controlled Substance Act violations, things like that. So all we're saying is that they meet all the requirements of the concealed carry permit except for BI. We're deleting that one. And we're deleting that one because it says is a resident of the United States and has been a resident of Wyoming for not less than 6 months prior to filing the application.
And so they're just striking that, Mr. Chairman.
Representative Craigo.
Mr. Chairman, thank you. I was just going to chime in here. I think the reason LSO stuck that where they did is because if we change the language of B1 below, then it shortchanges the procedure for someone in Wyoming. We still have the ability to get a concealed carry permit if we want, so that we can go to other states that don't have a non-permit jurisdiction. And so I think that's why they stuck it up there, because if we don't want to be giving out permits to non-residents in Wyoming. And so I think that's why they stuck it where they did.
Yeah, that's a good explanation, Mr. Chairman. And that's what I was trying to get at. I don't think we want to change that process. This is just simply saying that we want to afford
the same constitutional rights to all U.S. citizens. And we don't want to monkey with how we do our concealed carry permit process here in the state.
I knew I was getting there too. Representative Craig was just much faster than me. All right. Further questions for Representative Wharf? All right. Thank you, Representative Wharf.
Thank you, Mr. Chairman.
Clarissa, do we have anyone in our digital world with their hands raised? I have somebody on my list. I'm just not sure. I believe they're here for this bill.
Mr. Chairman, at this time, we have Mr. Cole, who has raised his hand, I believe.
All right, Mr. Cole. Come on in.
Mr. Chairman, members of the committee, I am amazed and impressed by your tenacity and patience in dealing with all the different bills and all the different hours of the day that you guys have to do it. Can you hear me okay?
We can hear you. Yes. I'm sorry we didn't get both of those bills up at the same time. So we could have saw you in person, but we appreciate you joining us via Zoom.
I was on dad duty today to do the school drop off, and so I was unable to join you in the morning. I promise to not make a practice of it when I can be there in person. So, Mr. Chairman, members of the committee, my name is Nephi Cole, N-E-P-H-I-C-O-L-E. I'm the Director of Government Relations and State Affairs for the National Shooting Sports Foundation, which is the Firearms Trade Association of America. I was also the Senior Policy Advisor for Governor Matthew H. Mead when we passed permitless carry in the state of Wyoming. And I also worked for the National Shooting Sports Foundation as we successfully lobbied this year to add 2 more states to those states that have permitless carry. So we were able to get Montana and Utah added as permitless carry states this year. That brings the total to 18 states that have a permitless carry statute. I bring that up, and I know that the good Representative Wharf may not have the most recent information on this, but there are currently 2 states, it's North Dakota and Wyoming, that have the residency requirement on permitless carry. Those are the only states. And then in Utah, Montana, and South Dakota, I worked to make sure, based on personal experience and my experience in the governor's office, that we recognized out-of-staters. I'd like to quickly explain why. It's because if you don't do that, it creates what I like to call a donut hole in the law. And so we dealt with this at the governor's office in Wyoming, where you'll get a call from out of state, somebody from out of state who has a permit to carry, but it is not a permit that has reciprocity with Wyoming. In most cases, if we do not have reciprocity, it's because their permit to carry is more stringent than ours, and so they do not recognize our permit. So, for example, New York or Massachusetts, which would have a much more strict permit requirement, well, that individual is going to Yellowstone National Park, calls and says, hey, I'm driving to Yellowstone. Can I carry concealed? And we'd have to tell them, no, you cannot carry concealed in the state of Wyoming because, number one, we don't recognize your permit because we don't have reciprocity. Number 2, you're not a resident, so concealed carry without a permit does not apply to you. And I only bring that up because it can create kind of an interesting, weird loophole. I just think it's worth we don't like the loophole. We think it's appropriate that we just treat everybody the same in this regards. So we are in favor of the change in this bill. I'd also like to say I think Representative Yin's suggestion is very prescient, and I would like to explain his suggestion. There are states such as the state of Utah that have become destinations where people will go to take training and to then gain a concealed carry card, because those states do not have a residency requirement. And so just as a FYI, that is how, my interpretation of what Representative Yin has suggested. I think that's what that would do, is it would allow Wyoming to host other individuals who wanted to have a Wyoming concealed carry, which then, of course, would have reciprocity with the 37 other states, assumably including a state that that they would come from. So with that, Mr. Chairman, I will try and keep it short. Thank you.
Questions for Mr. Cole? All right. Thank you, Mr. Cole. Additional testimony in the virtual world, Clarissa.
Mr. Chairman, I do not see anyone else who has their hand raised.
All right, we'll give them some time to think about it. come back to the room. Mr. Odekoven, I assume you would testify on this bill?
Thank you, Mr. Chairman. Byron Odekoven, representing the Wyoming Sheriffs and Chiefs. Let me start by suggesting that we are in favor of the idea that a law-abiding citizen may carry a weapon. The Second Amendment is important to us. Let me clarify a couple of points as I understand the bill and how that the practical aspect of it is as well. And I think you've almost fully defined the idea to start with, that the placement of this statute in the manner that it was done to not interfere with our ability to receive that concealed carry permit. The one point that was not raised in that ability to receive that concealed carry permit is the NICS check. So the possessor of that permit does not have to wait the waiting period for purchase of a firearm. So if you interfere with that section of the statute, you may interfere with that ability for our permit to be recognized for the ability to purchase a firearm without going through that waiting period. So the placement of this concealed carry in a separate spot of where Wyoming residents can carry, I think, is appropriate. On the first point. Second point, it is troubling for us to some extent. We've talked about law-abiding citizens. I get it. I have friends, neighbors come to Wyoming, relatives carry concealed. That would be fine, if you will. The question that I have for the committee is, I would hope at some point in the future, you would help us in the matter of dealing with those who are up to no good, if you will, the non-law-abiding citizen who comes. So at 3 a.m, the 3 guys that are riding with the dope dealer / whatever, who are the lookout / muscle, who are carrying the gun upon being the bill passing, near as I can tell, Mr. Chairman, I just get to compliment them on their style of weapon and their manner of carry and wish them a fond good day and deal with the one gentleman in the car who had the dope in his possession in a slightly different manner. Second of concern, if I may, is the idea of resident. And I think you touched on it slightly, and that is troubling because I did not do the research to determine for sure if that covers illegals or people who are in the country illegally, undocumented or whatever the word is I'm supposed to use today, so to speak. But those illegal residents who are residents, are they legal? So I ask that because we from time to time have the Mexican mafia traveling to our state, especially via Colorado, to distribute drugs and a few other good things. Are they covered by this or not? Unsure. Want to ensure that we're talking about legal law-abiding residents and not someone who would merely be a resident who is not legal, Mr. Chairman.
Vice Chairman Washut.
Thank you, Mr. Chairman. Mr. Odekoven, if your association would like to create some statutory changes dealing with criminal muscle, please see me in the interim and I'll be glad to visit with you about that. But also, Mr. Chairman, a couple of questions. One is Representative Worf talked about storing your weapon in your vehicle, and I wonder if the association has any comment about people leaving their firearms unattended in their motor vehicles while they're vacationing in Wyoming.
Mr. Chairman, it is always of concern at different times of the year, especially with people breaking into vehicles and liberating property from within. It'd be especially troubling, if you will, at this point with our budget crisis and the previous discussions we've had. It appears as though that minor theft will probably not be prosecuted in many jurisdictions due to budget cuts. If we continue down the course of the direction of the judiciary, if you will, and or the legislature, it would appear that those theft of firearms would be a nonviolent felony subject to lesser penalty, maybe even no fines or fees, and maybe even expungement relatively quickly. So yes, Mr. Chairman, theft of firearms or any other property would be of concern.
Unless the value of firearms goes up a lot, is what you're saying, because you're talking about the dollar amount change on the theft statutes. Oh, are they? Okay. All right. Well. Further questions for Mr. Odekol?
Thank you, Mr. Chairman. I look forward to the discussion of what a law-abiding citizen may accomplish and wait anxiously for what to do with some of those who are not so law-abiding. Thank you, Mr. Chairman.
Thank you, Mr. Odekol. Could require the members of the Mexican mafia to have a clear sign when they come into Wyoming, so we know who they are. That would be great. Anyone want to run that bill? Or any other mafia for that matter. Further testimony in the room on this bill? Nope. Okay. I suspect our county commissioners are interested in another bill. All right. Clarissa, did we have any hands raised? I just want to circle back to double check.
Mr. Chairman, we do not have anyone else with their hand raised.
All right, thank you. So with that, I'll close. Oh, I'm sorry. Representative Henderson. Just wanted to say thank you for coming to our committee and welcome. So are we, Representative Henderson. And thank you for wearing your hump day coat. Appreciate that. All right. Committee, close public comment. What is your pleasure on the bill? Moved by Representative Larson, seconded by Representative Crago. Discussions on this bill or amendments on this lengthy bill. Representative Ian?
Mr. Chairman, I'm not going to oppose the bill, but I do want to say, if it is the interest of the legislature, maybe one day we could be a destination and charge non-residents a lot more than we charge residents for permit fees. That's all. Thank you, Mr. Chairman.
Thank you for that note that I will stew on in my spare time. Any other? Whoa. Representative Lawrencer.
Thanks, Mr. Chairman. I was going to say, it looks like 18 states do allow this, us and North Dakota being the two states that are resident only at the current time. So 16 other states do it. I don't have a good reason why we shouldn't, so I'll be supporting the bill.
Thank you, Representative Lawrencer. Sensing Representative Larson is eager to vote. Would you like to vote? Let's vote. Kay, will you please call the roll on House Bill 116?
Representative Crago,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Williams,
Aye.
Vice Chairman Washut,
Aye.
Representative Yin,
No.
Representative Swanitzer, Chairman Olson.
Aye.
Mr. Chairman, you have 8 ayes and 1 no.
Thank you, Kay. Representative Worf, I suspect you'll want to floor manage your own bill. Well, I think you got a solid vote, so I imagine that may happen. And Representative Worf, maybe we can let you actually go to your own committee meetings now. I apologize that we've had you in front of our committee so long with so many bills, but we do appreciate you bringing bills to the Judiciary Committee.
I appreciate you having me.
Thank you, Representative Worf. Representative Crago. Let's go to House Bill 193, County Attorney's Representation of Special Districts. Walk us through this bill.
Thank you, Mr. Chairman, committee members. My name is Barry Crago, House District 40. I bring to you House Bill 193 and ask for your favorable consideration today. This bill is fairly simple in concept, maybe not as simple as I'd like it to be, but it's simple in concept. Essentially, it allows our 23 county attorneys who do the civil work within their respective counties to represent any special district located wholly within their county. And that provision's included because there are a few special districts spread around the state that cross county lines. So this would only include those districts that are wholly located within your county. I'm bringing this bill to solve a problem in my home county, as well as a few other counties, excuse me, around the state. For years, probably longer than I've been a lawyer, I would suspect, several of the county attorneys have represented a few of the special districts within their counties. For example, since I have been working for Johnson County, I've provided legal advice to our local weed and pest district. Other counties I know have done the same. Sometime this winter, the Crook County Attorney, Mr. Barron, requested an AG opinion on the matter and was instructed by the Attorney General that there is not statutory authority for a county to represent a special district. And I believe Mr. Barron provided us that Attorney General's opinion via email here this morning. As a result, I brought the bill so that I, as the Deputy County Attorney in Johnson County, along with some of the other county attorneys, may continue to represent some of the special districts, their clients, essentially, in their county. The way the bill is drafted, it will allow each county attorney to continue to do as it deems best within its own county. In other words, it only has to represent this special districts if they want. It's not a requirement, it's a may, it's not a shall. In small counties like Johnson County, like my county, it will mean thousands of taxpayer dollars are being saved every year. And in the current budget crisis, it seems like that would be a good thing. In closing, I'd just reiterate that the bill does not require any county attorney office to change its current operations. They can continue to do what they've been doing. We can continue to do what we've been doing, albeit apparently without statutory authority. So I'll walk you through the bill real quick. It's pretty simple. On page 1, there's a provision regarding the special districts, and it says that the special districts may request their county attorney located within their county to provide them legal advice. And I just want to, one thing, and I'll back up this, it's not really in the bill, but this doesn't typically involve litigation. This is stuff, it could possibly, but typically it does not. It involves reading contracts, going through grant awards, helping making sure that the documents they're signing are what we are saying, what we want them to say. And so that's my biggest job in representing these special districts, is usually contractual work. A lot of times when we get into litigation, usually involves the LGLP, the liability pool. Other lawyers represent them in lawsuits, so per se. I mean, occasionally we'll get into a collection or something like that, which is technically litigation, but it's not what we would think of as standard litigation. On page 2, 18.3.302, which sets forth the duties and responsibilities of county attorneys, subparagraph D is added and just says that each county attorney may act as legal counsel or give his opinion for questions of law for one or more special districts located entirely within the county in which the county attorney serves. That's it. 2 different provisions. It would become effective. The effective date is July 1 of this year, and I would gladly stand for questions. Thank you.
Committee questions? Representative Swanser.
Thanks, Mr. Chairman. Just a whole lot of questions. So, because I've sat through 2 special district total revisions now in my time here. And so my questions are, I mean, a community college district or a hospital district, they technically could ask the county attorney to do some work on their behalf. My question overall is, why is it so broad to allow for any special district? And at what point, now that they have authority, can county attorneys say no? I mean, does it not put county attorneys in a tough spot if they, a special district says, hey, we're being sued, it is a litigated thing, we don't have any money, county attorney come do all this legal work on our behalf, and the county attorney who's elected says, no, I don't really want to. Where the county attorney in the next county over might, it might be I don't know, 2 fire districts on a border of counties, and one county attorney says, yeah, I'll represent you, and the other district has to go get private counsel because their county attorney says, no, I don't want to be involved. So it's one of those, we give them authority. I guess I would feel better if we listed maybe which special districts, and what your thoughts on that are? Or is it just too broad, allowing the county attorney at will to pick and choose who to represent and when? And maybe also, second question, Mr. Chairman, what was the necessitating action if you know that we would have asked Attorney General, right? You never want to ask for permission. You always want to ask for forgiveness. Because now once you asked, you got the answer, and now we have a problem. Was there a necessitating event that required us to ask the Attorney General for their opinion on if we were allowed to represent special districts?
Mr. Chairman, Representative Zwanzer, thank you. So I'm going to tackle your second question first, because that's the easy one. I suspect County Attorney Barron will be on, and we can ask him exactly why he decided. I know a little bit of the backstory, but not all, and so I'd be more comfortable if we let him answer that question. As to where to draw the line on what districts we can or cannot represent under the bill, I thought about this. I talked to several of the county attorneys around the state. That was one of their main concerns. I don't know where to draw that line. I will say this though, most of the bigger districts, whether we're talking community college districts, whether we're talking hospital districts, whether we're talking in schools, I understand they're not a special district, but they all usually use specialists for their lawyers, and there's a reason why. And so they have bigger problems, bigger fish to fry, and they have to deal with more complex issues. And so in our county, we don't represent any of those districts. Those are all represented by different counsel who have expertise in those areas. And I don't think, I could see a situation where we get into a position where the district does not have any money. This would allow the county attorney to say, okay, I'd rather I put in some extra hours and represent you than the district have no legal representation at all. It does put county attorneys in a tough spot. I'm not going to deny that it does not. That is true. There will probably be some asks, and I bet we hear testimony about that today. But we're all public officials. The county attorneys are elected, just like the 9 of us sitting here today, and we all have to make tough decisions and answer to our voters on different issues. And so I would rather we have the option to do that than not. And yes, there could be that predicament that arises later on. But the way I foresee this happening is that the status quo will be maintained. The districts that have their own lawyers are probably happy with their own lawyers and would continue to stay with that legal counsel. And including in our county, I hope I don't get fired from representing the weed and pest district because we passed this bill. But that's how I see it. Is I don't think it changes the status quo, nor do I think it will going forward for the most part. There may be some asked here and there, and I think at least this way it leaves it up to the local official to decide that.
Is there any worry that involving the county attorney will open up the county to liability? Someone's suing a special district, county attorney then says, well, I'll represent you or do some legal work on your behalf. All of a sudden now you've not only the special district's not online, we've now opened up the entire county based on the county attorney's opinion for being included in, let's say, a lawsuit. And I don't think those are going to happen very often, but I do see some cases in like in Niobrara County or Hot Springs County where maybe their school district says, hey, the best person's a county attorney. Let's just have them, instead of hiring expensive outside counsel, give your legal opinion county attorney. And all of a sudden now the county as a whole, based on that county attorney's opinion or legal work, is now a party in the case. I'm always thinking worst case scenario here. Are you concerned about that? And would it make more sense, or what would your comfort level be, either delineating special districts or delineating, if the district has more than a certain, asset limit or budget or something, of drawing that line somewhere? I'm so worried about not having a line somewhere and it being a free-for-all. If you could comment.
Mr. Chairman, Representative Zwanzer, I'm not worried about that. I think we all go into as lawyers, we understand that responsibility, and we go into that every day. knowing that's our responsibility to provide the best legal advice possible, whatever that is. And I don't think it exposes us to any additional liability on that realm. I'm open to suggestions on if this body wants to draw a line. I'm not opposed to that. That's personally, I want us to be able to represent those smaller, especially in our small counties. Okay, that's what we're really talking about here. I don't foresee this happening in most of our bigger counties, our bigger populations. I don't think this will even be an issue. It's in our smaller counties where we do have the ability to help out and save some money and save some resources. I've been doing this as long as I've been a deputy county attorney in Johnson County, and it's worked out well. And I know that's the same circumstance that probably Mr. Barron's going to talk about. He's in a small county, and there's not a lot of us actually. I want to say there's 5 or 6 of us that actually do this, and they don't. Every county, every district is a little bit different, and so different county attorneys represent different districts. And I think if we took a poll, we're probably not talking that many special districts actually. This might open it up to a few more in different places, like you alluded to earlier. I'm not drawing a line in the sand and said we have to do it this way or not at all. Definitely not saying that. If the body or if this committee or the body as a whole wants to come up with an amendment regarding that, I'm not opposed to that.
Representative Larson.
Mr. Chairman, not a lawyer, not in the legal world, so I have no idea.
You should be thankful.
Yeah. The question I have is being employed by the county attorney, I'm guessing from your county, can you take your hat off and do this during the weekend, or you can't do any other legal matters other than county issues? I don't know if that's my question, but I don't know if it's the right way to put it.
Mr. Chairman, thank you. Representative Larson, so it fits into my time schedule, and I think it does in other county attorneys' offices as well. So do I work on the weekends doing this stuff? Absolutely. Do I work at night, go to meetings for these boards? Absolutely. But I also do it during the day. I mean, if I get a contract in from one of the special districts and they say, hey, can you read this grant award and make sure it says what we think it says? Yeah, I'll do that during the day. But usually our meetings are at night. They're rarely on the weekends. I might do work on the weekends, but that's probably because I work too much, but that's just what I like to do. So, it does not affect my job as a county attorney. I think my chairman of my county commission is here, and he probably could attest to that it doesn't, at least not in I can't speak for everyone, but I know in my particular circumstance, it does not affect my job to do my other county duties.
And Representative Crago, maybe to help Representative Larson, because I think what he's trying to get to is other than, set special district contracts aside. I think what Representative Larson is asking is, can you as an elected county attorney do other private matters on the side or on the weekend? Can you have other contract work? Can you Can you do a divorce? Can you do other things?
Thank you for that clarification, Mr. Chairman. Depends on which county you're in, and there's a couple different modes that different county attorney offices work on, and it depends on whether a resolution has been passed by your county commission. Some county attorney offices are full-time and some are part-time. And so if your office has created a full-time office, then you cannot represent outside that office.
Is that helpful? I've always had the same question, actually.
Mr. Chairman,
go ahead.
So chain of command, your elected county attorney now designates you, let's say even in Johnson County, as are you the chief civil deputy? I can't remember your official title, but you're not the county attorney, obviously. As an employee of the county attorney's office, the county attorney under this bill would make the determination whether or not to give that legal advice or counsel, and decide. The county attorney who's elected would get to decide what to task all of the deputy attorneys with doing or not doing Would that be a fair statement that the elected official gets to make the call on which special districts are in and which ones aren't? And then added that workload, whether or not their staff agrees with it, saying, hey, you're going to do this. I think we're going to represent the weed and pest or the fire districts now, and that's part of your job.
Representative Craigo?
Mr. Chairman, Representative Swanitzer, that's exactly right. It's left up to the elected county attorney for each county. Well, I say that it would, in the two counties that have DA's offices, they are an appointed position, actually. The civil county attorney is an appointed position in the 1st and 7th district.
Yeah, I was going to ask that question earlier just for clarification in Representative Zwanitzer's initial questioning, is that in Laramie County and Natrona County, we have an elected district attorney who only deals with the prosecution of crimes, but we also have a county attorney which serves at the pleasure of our county commissioners. And that's what you're referencing, Representative Craigo, is that we're the exception. The rest of the counties elect a county prosecutor who will deal with, they'll have a civil division and a criminal division.
That is correct. Thank you, Mr. Chairman.
Representative Swanitzer.
And so we do have places in our statute that says in R2 Laramie and Trona County, when we say county attorney, we just mean district attorney. But in this statute, we would completely mean county attorney, not the district attorney, right? Or are we including if the district attorney wanted to give their opinion on a matter of a criminal? I'm trying to think, well, you could have a criminal conduct certainly in a special district, right? Embezzle, I mean, any number of things. How does that interplay work? It would go to the district attorney in those two counties to agree to give opinion or advice? Or could they stop it from the county attorney? Because I am always a little confused in our county. The county attorney reports to the county commissioners, but not to the district attorney. Any concern there on an interplay with an issue going to the county attorney? Because our laws really say that anything criminal, county attorney is district attorney in our two counties.
Mr. Chairman, Representative Swanitzer, the way I understand the law is that in 21 out of the 23 counties, it would go to the county/prosecuting attorney, right? In District 1 and District 7, here and in Casper, it would go to the appointed county attorney to deal with those civil matters. Because if you read the statute, that is the person responsible for representing the elected officials within that county.
And I think, and I could be wrong, but I think what the statutes do is they refer to, I don't even know if they use prosecuting, but they use county attorney to refer to county attorneys. They use district attorney to refer to district attorneys. But I think in our layman speak, we often will say DA, district attorney, and we're talking about someone who prosecutes because we have a federal DA. We have these two DAs in these two counties. So I think we interchange them, but I think the statute only, I don't know, it only says, I think it's a good question. I want to be clear that we don't refer ever in our statute to our district attorneys as county attorney or prosecuting attorney that may cause some type of, here, I guess prosecuting wouldn't matter as much. It's county attorney specifically. Are we confident we don't refer to county attorney? We don't refer to the district attorneys in Natrona and Laramie County ever by county attorney?
Mr. Chairman, I'd have to go grab my statute book to tell you where that exact statute is, but what the statute sets up, the way I understand it, again, without looking at it and running off the cuff here, is it delineates that criminal actions are to be prosecuted by the quote unquote district attorney. And then that statute goes on to say that in those counties which have not elected to go to the district attorney system, that those job duties are delegated to the elected county attorney.
Okay. Well, we can always double check it later at some point if we're worried about it. So thank you. No other questions, Representative Swanitzer? Nope. Committee, other questions for Representative Craigo? No? All right. Who do we have in our virtual world? Anyone with their hands raised who would like to testify on House Bill 193, Clarissa?
Mr. Chairman, Mr. Barron has his hand raised.
Let's go ahead and let Mr. Barron in. Mr. Barron, I'm gonna switch things up a little bit for you. I'm bringing you in first to testify in hopes that that way I don't have you at the end. I don't have to cut you off. So maybe that'll help. Let's try that.
Thank you, Mr. Chairman. Chairman Olson, my name is Joe Barron, Crook County and prosecuting attorney here in Sundance, Wyoming. I stand, first of all, with regard to House Bill 213 on behalf of the County and Prosecuting Attorneys Association, who is opposed to this bill. And they're opposed to this bill basically because of the lack of funding, the lack of time to carry out the duties, and the potential conflicts of interest.
Mr. Barron, sorry, I think you meant 193, right?
230, is it 193?
Yeah,
I'm
you said
sorry, I got
213.
I'm sorry. Yeah, a little bit of
No worries. I just want to make sure we're both on the same page. Thank you.
Yes, yeah, and so the association is opposed, frankly, adamantly opposed. I think we have 21 of the county attorneys that, I don't know what the count is, but it's well over the 17 that we require to oppose this bill. And so the county attorneys are opposed, and the prosecuting attorneys, which we represent the county attorneys and the district attorneys throughout the state, and we're opposed to this bill for those reasons. And I would stand for any questions that you have to get down into the weeds about these things. Just to answer one question that was brought up, district attorneys, what a county and prosecuting attorney does, the elected county and prosecuting attorney does in the statutes, we do everything that the district attorneys do in the two counties, in Natrona and Laramie County. In addition to that, then we handle the civil requirements of representing the elected officials in our counties and our board of county commissioners on that.
Thank you, Mr. Barron, for clarifying that. And just if you know, do you know if in our statutes we ever refer to a district attorney as a county attorney when we're discussing them in statute?
Mr. Chairman, we do not. The way it usually works is that you describe things in the statutes, anything that's related to district, that's related to criminal matters, it refers to the prosecutor as the district attorney, and which includes us because we have that authority under statute where the district attorney has not been appointed to the county, elected county attorney fulfills those roles.
Very helpful. Representative Zwanitzer.
Thank you, Mr. Chairman. Just quickly, Mr. Barron, I'm of the understanding that it was a request from Crook County on whether or not they could represent the Weed and Pest District is somewhat where this bill came from. Is there, I guess, any other information? Did someone make an allegation that the county shouldn't be representing? Or if you could maybe just extrapolate on why the request to the AG was made, I'd be appreciative.
Mr. Barron.
Chairman Olson, Representative Zwantner. Yeah, I can tell you because I made the request for the opinion. Historically, what had occurred is that since I've been working at the county attorney's office in Crook County, that I had, it was my job as a deputy when I first got there, was I got to represent the Weed and Pest District. And the county attorney's office has historically done that before my time, and we just did that. The reason that we did that was because the Weed and Pest District Board is solely appointed by the Board of County Commissioners, just like your library board, your fair board, and boards that are created under Title 18 that are solely created by boards of county commissioners. And so I didn't see much difference in the wording of the statutes, things like that. The only real difference that I saw with Weed and Pest District is their mill levy for their 2 mills that they get. It comes outside of the statutory 12 mills that counties receive on their tax base for mill levy. And so historically, I had done that for ever, right? 34 years. Then it was brought to my attention by another county attorney who basically was looking at it. He was a new county attorney and he was looking at it and like, I don't think I should be representing these people. And because he had some concerns about, if he didn't have a statute that provided coverage, then there may not be any qualified immunity for what he does in representing that particular entity. I frankly had never thought about that. But anyway, so he told me that he contacted the Attorney General's office and they gave him a verbal opinion that nope, he couldn't do that. So he was fine. And most county attorneys around the state do not represent any special districts. Most of them never have. And most of them just frankly don't have the time, the funding, the manpower to do that. I would tell you this, when I started this job, my civil representation of the county was 5% of a part-time job. Now my civil representation of the county and the elected officials that I have is coming close to a full-time position job. It's at the very least a half-time job, and to do it properly, it's a full-time job. So what I did was I said, I don't agree with that. So I asked for a formal opinion, and they gave a formal opinion, and we got the answer back. And so I notified my Weed and Pest District that, hey, I can't represent you because this opinion. And so that's how the matter came about.
Thank you, Mr. Barron. Representative Oakley, please.
Thank you, Mr. Chair. Mr. Barron, I guess my question is, since it is written in a voluntary manner, I mean, the bringer of the bill, like if Johnson County wants to do this, does that change things as far as your opinion? I can say that I ran it past our civil attorney. She said, I don't want any extra work, but if it's voluntary. And then she also brought up possible conflicts, but of course I think that could be dealt with individually. So if some smaller counties want it, would you still be opposed, I guess?
Mr. Barron, go ahead.
Mr. Chairman, Representative Oakley, the position of the association is that they are opposed to this bill of adding things because of the conflict of interest and because of the lack of funding and the lack of time to take care of these matters. Personally, I have mixed feelings about this. One of the problems that has occurred, and I'm not saying it's a problem, but what has occurred over the years is Weed and Pest Districts were a fairly standalone entity. But since that time, and that's the one I represented in the thing, but since that time, there has been increased duties placed upon Board of County Commissioners and other county elected officials for oversight of special districts. Right now, there are statutes that any board member that's appointed by a county commissioner can now be removed by the county commissioner, the Board of County Commissioners. So if I'm representing that board, and now I got board members that are in turn going to be removed by the Board of County Commissioners, which I have had happen in several occasions on that, where am I at on that? who do I represent? You know, and a lot of these things you just can't plan for these events because they exist. There's also the legislature has passed some statutes dealing with special districts, the Open Meeting Public Records Act, that's kind of thing, as they deal specifically with special districts under Title 16-12 it started out with 101, and then now it's up to 1612, 201, and 301, and then 402, dealing with various aspects. And so there is a list in there in 1612, 202 of special districts that are defined as such, and thankfully school districts aren't included in that. But it gives a list of who is in there that could be represented. And there's like, if my Roman numerals are correct, there's like, 23 plus other districts that are not named that the potential exists. So the problem that I see as a practical matter is there's a lot more conflicts than existed a long time ago. And in the election laws and the formation, right now I'm dealing with the dissolution of a special district. Had I represented that board, how do I now go through and take the other side and represent the Board of County Commissioners in dissolving that entity? Although in the past I was in favor of this, I'm to the point, I just think it's getting to a point where it should be avoided. It should just be avoided.
Representative Oakley, do you have a follow-up?
No, thank you, Mr. Chair, and thank you, Mr. Barron.
Committee, further questions for Mr. Barron? Nope. Okay, thank you, Mr. Barron. Clarissa, do we have additional folks in the virtual world who would like to testify?
Mr. Chairman, I do not see anyone else with their hand raised.
Thank you very much. Representative Henderson? We didn't bore you. Okay. All right. Thank you for joining us. And then there were two.
Mr.
However you
Chairman.
want to start, whoever wants to start.
Mr. Chairman, members of the committee, I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. I'm joined by Mr. Bill Novotny, who is the chairman of the Johnson County Commission and happens to serve as our vice president. Mr. Chairman, my members do stand in support of this bill, and I'll give you a couple of reasons for background, and Mr. Novotny can fill in where I miss. We really appreciate that this is a permissive opportunity. And I look at it as a permissive opportunity, both in part and in whole. What I mean by that is that the county attorney can make a decision whether they want to represent that special district just on one issue, on one contract, or perhaps if they want to represent them in the entirety of the business that they might operate. It doesn't demand that they have to do that. Mr. Chairman, members of the committee, the other reason, and I think this is more pressing for my members in terms of their support for this, is that you can look at this two ways relative to the budget. My members have to consider the budgets of most of these special districts and then ultimately set the mill levy for that special district. So they can make the decision about whether it might be appropriate for them to have a line item for county representation from the private sector for their interests. Or my members would look at it and determine whether the county attorney's budget might be able to, or time or budget be able to bear some of that expense. So ultimately, it gives my members some opportunities to look at where cost savings might be achieved through the system and ensure that the taxpayers receive that benefit. Again, Mr. Chairman, my members do stand in support. I'd be happy to answer any questions. I would ask Mr. Novotny to fill in where I've missed.
Do you want to give some comments, Commissioner Novotny, before we ask questions, or it's up to you? What do you want to do?
Mr. Chairman, if I could make just a few brief statements.
Yep, go ahead.
Good morning, Mr. Chairman, members of the committee. My name is Bill Novotny. I am chairman of the Johnson County Board of Commissioners. Within our county and many of the other counties, you have county commissioners who serve as liaisons to special district boards. So you become very involved in their day-to-day operations. And I think one of the things that has not been brought up is the area of personnel and just day-to-day operations, because it's so much more than the annual review of a contract that a special district has. It's when a special district has an employment question, or the special district needs to terminate someone's employment, when the special district needs to update their bylaws, their personnel policies. All of these things are, in the case of Johnson County, being provided by Mr. Crego. And the work that Mr. Crego does on behalf of our special districts saves them thousands and thousands of dollars each year. And his availability cuts into his private time and his private practice, to be honest. But he does that because it's the right thing to do. And I just, on behalf of the taxpayers, I know it does create a little additional for county attorneys, but they choose to do that additional work. And so we would ask for the permission to continue the practice that we have. Now, I do want to push back a little bit against the discussion about conflicts between the offices, because if you look at the county attorney, they are constantly in conflict. When you have a Board of Equalization hearing, they are representing the assessor before the county commissioners. We had a situation where we actually had to get an opinion out of the AG's office where the county commissioners were in conflict with the coroner, who was a provider of service to a special district. And the AG's office said, nope, not going to touch it. Your county attorney is going to have to figure this one out. So I would strongly encourage you to move this forward, even if the County Attorney's Office Association has come out against it, because again, it is permissive. And in that job that they have been elected to, and look at the membership of your special districts. Those are elected members who are political subdivisions of the county created by the voters. It makes no sense, other than someone complaining about workload or wanting more budget, not to move this bill forward and to allow the county attorneys that would like to serve this function to do it. It's good for the taxpayers. It's good for the people, and I'd stand for any questions.
Bill, Mike, so I think you just really answered the biggest question I had, because the testimony that I thought, if I understood the County Attorney Association correctly, was that it was I think an unfunded mandate is what I heard. But so help me understand that, because the statute couldn't be more clear. It's May. I think we all get that. But what I'm wondering is what that really means. Is there, if it's permissive, is there a scenario for maybe political reasons in a community that would force the county attorney's office to take the contract even though they didn't want it? I just don't understand how it goes from being permissive to a county attorney requiring to take the special district on and then not be able to do the work. Is there a scenario?
Can I add on to that, Mr. Chairman?
Yeah.
If I could just add on to that, is there a scenario where they go to the county commissioners and the county attorney says, I want a higher pay raise, but we're going to take on all the special districts, we'll represent them, and we would like a higher salary for our county attorney's office because we're doing all of this extra work? Do you foresee that ever happening?
Mr. Chairman, Representative Swanser, as well as Mr. Chairman, that's going to sort itself through the normal budget process that commissioners engage with their county attorney's office. And I hope that the county attorneys aren't listening, because when that statutory budget cap is set. It is set, if a county attorney overspends their budget, we really have no statutory authority other than getting to the end of the fiscal year and having to advertise additional money into their budget. That really is how the process works. You know, we're all trying to live in the new financial realities that the counties are facing. And I don't foresee a Board of County Commissioners forcing the county attorney to do anything. And certainly, I don't see it that if they took on this additional work, the commissioners are going to do the very best that they can to provide the county attorneys with the resources. We have to have great relationships with our county attorneys because they're so integral in the day-to-day operations of our counties.
Thank you. Vice Chairman Washington.
Thank you, Mr. Chairman. Mr. Novotny, thank you for coming down to the big city of Cheyenne for the day. My question is, once your deputy attorney is engaged with the district, does this law allow that attorney to pull out at some point if it turns into bigger litigation than they can manage, or it seems to create an undue conflict that they don't want to be involved in, such as termination or removal of someone from a special district? I read it as allowing to come and go whenever you want. Is that the way you read this, Bill?
Mr. Chairman, Representative Washit, yes, that is my interpretation, and I would defer to Representative Craigo on nuances of that, but absolutely, the county attorney's office makes decisions all the time when they need to bring in, let's say, outside counsel from another county to prosecute something, or in our instances, we're involved in several mineral bankruptcies. The county attorney's office has decided they don't have the expertise for that, so they hire outside counsel. So absolutely, they can make the legal decisions and also the ethical and the judicial canon questions that might arise when they're in that position and make the appropriate decision.
And maybe to follow up on that, and maybe for Representative Craigo, you know, I'm not a government lawyer, I'm a private lawyer, run a law firm, got a half a dozen lawyers. They take cases from all over the state of Wyoming all day long, every day. And conflict happens. And our rules allow us to navigate through conflict. Number one, this is permissive. So if a county attorney viewed a conflict, they would say, oh, I can't take that case. And they wouldn't take it. Same thing I do in my office, right? When there's a conflict, I see it right up front. I don't take the case. However, I have the opportunity in some instances, depending on the rule and the scenario, to have both clients that may have an appearance of a conflict of interest to waive that, to have the joint defense, i.e. it'd be most common in criminal defense where I might represent multiple defendants accused in the same crime. But I can always, both clients can waive into that. Would that be the similar scenario here with the county? The county and the special district could both sign a waiver saying they understand the potential for conflict of interest if something arises that would require the attorney to withdraw, and they all consent to that. Is that how that would look?
Yes, Mr. Chairman. I mean, as you know, we have a separate set of rules for that deal specifically with our conflicts and how we navigate through that. And so that's exactly right. I mean, if we really want to delve into conflicts, we have conflicts. The conflicts I deal with on a day-to-day basis within the county are much more problematic than the ones I ever deal with on the special districts. I am tasked with representing all of the elected officials within our county. And if you think there aren't conflicts on day-to-day issues, you're sorely mistaken. And so I have to deal with those and figure out, because that is a shall. That is not a may. That part of the statute is shall. And so we have to deal with those. And so I think those of us that do this line of work have become adept at figuring out how to navigate those minefields. And so that's why I really enjoy the may language here, because we can decide what we do or do not want to do, or can or cannot do, based on our other rules that guide us, you know, on the lawyer side of things. Thank you, Mr. Chairman.
Further questions for the commission or commissioner? All right. Thank you. Any additional public testimony on House Bill 193? All right. With that, I will close public testimony on House Bill 193. Committee, what is your pleasure? Oh, Moved by Vice Chairman Washit, seconded by Representative Oakley. Amendments or discussion on the bill? Representative Oakley.
Thank you, Mr. Chair. I think, excuse me, it just seems to me something hit on by both Mr. Reaman and Mr. Novotny, as well as the bringer of the bill. The financial decisions are made at the county level. And what this does is allow the ebb and flow that needs to happen, that does happen with that body, with those decision makers. And so it seems to me that allows each county to make, allows each county to make their decisions, which is what they're tasked with anyway. So it seems to me that we need to allow the counties to make these decisions for themselves. And it appears this is what Johnson County wants to do. And I think it makes sense that those decisions would be made within the county at the county level. So I'm in support of the bill.
Thank you, Representative Oakley. Representative Zwanitzer, having spent more time with special districts than anyone I know.
As me too, Mr. Chairman.
Former chairman of corporations, current chairman of corporations.
And we will have several special district bills this interim. I'm going to support the bill. I do think it needs some amendments and some delineation, but there is a need and a problem we're trying to solve and address. And hopefully we can do some amendments on the floor and at least solve the problem, maybe temporarily for the next year until maybe a larger study can be completed.
Vice Chairman Washit.
Thank you, Mr. Chairman. I'm on the board of the bill. I think most, like our community college districts, most of those transcend a single county and they have their own counsel. They're not going to be coming to the county attorney to represent them under this bill. And I tend to agree with Representative Craigo that the status quo is what we're going to see. Those counties that want their county attorneys to do this will continue to do it. They've been doing it. And those that think that this is a excessive workload won't. That's what I think is going to happen. So I'm on in favor.
Thank you, Vice Chairman Washit. Any other member? I think that was a really good point. I always look at this from my perspective, Vice Chairman Washit, because I am not a government lawyer, I'm a private lawyer. So what I just heard is if a county attorney doesn't want to take the contract, doesn't take the contract, and it opens up, and maybe there's a lawyer out there in the private world that'll take it and do the work. Sounds like it'll get done. All right. Question on the bill. Kay, will you please call the roll on House Bill 193?
Okay, Representative Craigo,
Aye.
Representative Larson,
No.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Williams, I'm sorry,
No.
Vice Chairman Washit,
Aye.
Representative Yin, Representative Yin,
No.
Representative Swanitzer. Aye. Chairman Olson.
Aye.
Mr. Chairman, you have 5 ayes and 4 noes.
Thank you, Kay.
You're welcome.
Wow, committee, that cleared my desk, our desk. Good job, committee. We're getting it down. I appreciate you very much. Kay, thank you. Clarissa, thank you. We did good today.